Welcome. I am John Miller. I am the founder and senior attorney and owner of Rock Solid Law. Today, we're going to complete our series of webinars on the sandwich generation and what that means for, particularly for estate planning for families in America, families in Florida. Specifically, we're going to talk today about what parents can do for their young adult children and to make the entire family's lives better. So we've been talking about the sandwich generation, and which has been particularly created over the last perhaps 100 years, maybe a little longer, due to the fact that with medical advances, folks are living a lot longer. We've mentioned previously that in the Middle Ages, the average lifespan for a European human was about 32 years. 32 years. We consider that just getting started, at least from my perspective, we do. And now in the USA, one can expect to live to be 80 fairly reasonably. And I would postulate that someone born today has a reasonable life expectancy of reaching 100 years and more, given advances in cellular research and medical science. So there is a greater propensity for the creation of a sandwich generation. A sandwich generation is a group of middle-aged adults who care both for their aging parents and for their own children. It's not a specific generation like Gen X or the baby boomers, the greatest generation, but it's a phenomenon that can affect anyone whose parents and children need support at the same time. And as you would intuit, it moves throughout time. It's not like the greatest generation that we think of, the World War II era young adults, or the baby boomers who technically ended in 1964. Read a fascinating article recently. They're calling it the Joe generation, the very end of the boom. I always called it the end of the boom because I'm in there. Say people that were born in the late 50s through 64, who really have a very different generational identity than the first baby boomers, who were, of course, by definition, born after the veterans returned from World War II. So the phenomenon was recognized in the late 20th century as changes in lifespan, and a later age for childbearing meant that families had small children and frail parents at the same time. So for example, in the early 20th century, a woman might normally or averagely, if that's a word, have her first child around the age of 20, sometimes even earlier. And when her own parents were around the age of 40 and not typically in need of any special care. So she would raise her own family, and then thereafter would be the opportunity to assist the preceding generation as they aged, not having the two at the same time or creating the sandwich. More recently, in developed countries, women often have children closer to the age of 30 or even more. We know lots of people who have children in and around 40 these days, when their own parents are around the age of 60 and therefore at a much higher risk of needing support before the grandchildren become adults. These sandwich people become responsible for caring for their parents and their minor children at the same time. They may help their loved ones with tons of stuff like daily functioning, medical services and supervision, giving medications, anybody been there, and aiding in financial and most notably legal affairs of their loved ones, as well as of themselves. So really they're taking care of not just two generations, but three, including their own. Now in the series, we have looked at how they can best care the sandwiched generation, the meat, the cheese, the lettuce, the tomato, whatever else you put in the middle of that sandwich, how they can best take care of their aging parents through estate planning, how they can best take care of their minor children through estate planning, how they best take care of themselves in estate planning. And today we're going to look at what happens when those minor children become young adults and how that can affect estate planning for a family. So this is an unbelievable statistic to me. More than 1 of every 8 Americans aged 40 to 70 is both raising a child and caring for a parent. 1 in every 8. Is that incredible? 12.5%. So 8 adults walking down the street, 1 of them's caring for both a minor child and their aging parent. And in addition, that means caring on site, right? In addition, 7 to 10 million adults are caring for their aging parents from long distance. How about that? So the U.S. Census Bureau statistics indicates the number of older Americans age 65 and older will double by the year 2030. I will help that statistic to over, ready, drum roll, 70 million individuals, meaning that the number of people who will be caring for minor children as well as their parents will continue to grow. And it's not always just parents, right? Sometimes it's uncles, aunts, and even grandparents in these areas. So you may ask yourself, what is it that we can do for our young adult offspring that will make their and our lives better? Have you ever thought about the fact that on your child's 18th birthday, you no longer have a legal right to provide for her or him in many ways? Now, we all know that, in fact, at 18, people are just entering college and they're still hoping to be supported by their parents for a good number of years. But legally, one gains capacity, one gains a majority or adult status on their 18th birthday. So some of the things that you're no longer actually legally able to do for your young adult child is dealing with the same doctors you've always talked to, or dealing with any and all bankers, lawyers, insurance agents, mortgage companies, landlords, and any of a number of other legal relationships that young adult might be involved in, right? So on their 17th birthday and 364 days, you have the right and the ability to manage their bank account, to call their insurance company because they had to get insurance at age 16, right? And to do any number of other things. But on that next day, all of your legal rights are gone. Think of what if she or he gets into a car accident or any other type of accident. Wouldn't you want to seamlessly be able to come to their rescue, to legally be allowed to assist in the emergency care, or to help them with respect to all of the number of legal things that occur if, God forbid, there's an injury as a result of the accident they caused? So let me tell you, I've seen it all. I've practiced 37 years now. Most of the problems I see for families come from a failure to properly engage in estate planning. And it covers everything from failing to execute a power of attorney for yourself, so they will not be a necessary guardianship, to failing to protect your minor children from the battles of guardianship, and failing to protect your young adults from the perils of the big wide world. That's why here at Rock Solid Law include in the preparation of every estate plan package an affidavit for young adult children to execute, giving their parents power of attorney, just so that in the case that an emergency arises, the parent will be able to handle matters for them. It's really a very simple cure to a huge problem that, granted, most people never face, but those that do are suddenly in an emergency capacity and often don't have the ability to cure it after the incident has occurred. So it's another case of a stitch in time saves nine. I've said that regularly throughout these webinars, where if we can get that affidavit in place before your young adult children do something that they need your help, you are legally able to assist them. It's not a big deal, but it's a big deal if you don't have it when you need it. What you need to be sure of is that you've directed who will be chosen for this important role as a part of your overall plan. Yes, it is often one or both parents, but in America today, we have any number of family situations. So sometimes it's not one of those two parents at all. You also need to be sure that you have a simple will in place, and preferably a trust, if appropriate, so that the transfer of assets can be managed easily between generations without undue stress, the cost to your children and their new guardians. So switching from you need to get them to permit you to legally take care of them to you need to take care of them by taking care of yourself, because there's almost no person that's more a fish out of water than a young adult who is trying to manage both the grief of losing their parents and the legalities of continuing forward with the, let's hope not, probate or trust administration of their parents' estate. Few of them are yet really capable of financially making appropriate decisions. And the ones left in the best situations are those where their parents have left a playbook, essentially, of how they're going to manage the future of the family. You know, in the post-death of the parent scenario, the child is trying to deal with the distribution of assets, both legally and otherwise, the fair distribution of them, and the manner in which they're going to be split up. You know, not all assets are liquid, so it's not exactly like making change for a dollar every time. The administration, which I have talked ad nauseum about how probate can be a nightmare for families. And when that nightmare occurs, it entirely affects the legacy of the deceased, right? Managing the assets. What if there are rental properties? Does a young adult really know how to do that? And have you thought through who would do that for you during that period of time that can easily be managed in a trust scenario? The expense that parents leave behind for their children to pick up the tab on can be extraordinary and can be significantly more than the cost of getting a trust in place that will take care of those young adult children. And few young adults really understand the tax structure in our country. I would postulate that few mature adults fully understand the tax structure of our country. And once you get a handle on it, of course, the government changes it, so it's different. So really thinking that a 20-something would be able to properly manage the estate in the tax scenario is bafflingly inaccurate. So a big part of what you can do for your young adult children is to have your own estate plan in place, to properly care for them so that you're not a burden on them should you become ill or, in fact, die. A quality estate planning firm is going to do flips and turns in order to assist you in protecting your adult children, to make sure that what you worked for your lifetime will be distributed easily and at the least cost possible to those that you love. While we're living longer nowadays, we're not immortal. And accepting this simple fact, it only makes sense to consult with an attorney trained in assisting families in smooth transitions. Envision the peace of mind that you will have knowing that you've provided for your children for the unlikely and unhappy event that you're no longer able to do so. I also have a theory that once you have your estate plan in place, you have peace of mind, you sleep better, and you live longer. If you have any questions, there is a question bar, ooh, big hand right down here at the bottom. You may also email us at questions@rocksolidlaw.com, and we will be happy to provide you with our pamphlet, the Estate Planning Survival Guide, and answer any questions that you might have that are not of a general nature and perhaps are not appropriate to be asked here during the webinar. If you do decide that you're ready to move forward, take care of yourself, your young adults, your minor adults, and perhaps even your aging parents, we'll be happy to sit with you and discuss your goals and for the future of your family. Not seeing any questions this morning. I think this is a fairly straightforward subject, and I will look forward to switching to another practice area of ours, real estate, next week, when we will talk about the cost of closing real estate and the new app that we have. I'm very excited to roll out this app. Oh, look at that. I say app, the sun shines on my face. Isn't that wonderful? The new app that we have that will allow realtors and sellers just to go in and plug in the details of their transaction and see what the costs are on the title side. Thank you so much for joining us. Again, I'm going to leave you with Zoom for our Zoominar this morning. That is, of course, the Commodores, featuring Lionel Richie and Clyde Orange. Have a wonderful day. I am John Miller, founding attorney, Rock Solid Law.